Well, good afternoon, everyone. I'd like to welcome you here and thank you all for enduring these tube strikes to make it here in person to join us for what I hope you all agree looks like a fascinating afternoon of informative discussion. It's fantastic to see so many familiar faces here and indeed to make new connections with you. This conference is entitled Derelict to Dispute: Navigating Legal Jeopardy in Development and Regeneration Projects. Serle Court is the leading commercial chancery set, and what that means for our real estate practice is that we have a unique ability in Chambers to deploy expertise across a range of practice areas. As we know, commercial development projects and modern litigation is rarely about a single issue or point of land law. When disputes present clients with a range of practical and legal issues, whether it's in relation to restrictive covenants, easements, insolvency, urgent injunctive relief, infrastructure, funding, or other commercial considerations, Serle Court has that wide range of expertise to help clients navigate those disputes. And we're very pleased to be able to demonstrate that breadth of expertise here today. In this conference, we're going to examine some of those topics in the context of redevelopment and regeneration in real estate projects. In addition to hearing the expertise of my colleagues here at Serle Court, in our final panel session of the day, I'm delighted to be joined by a distinguished panel of guests from the OPDC, the Mayor's London Development Corporation, Ballamore and Homes England, where we'll examine what a successful regeneration project looks like. We're also very pleased to welcome our friends from GIA. In particular, one of GIA's board directors, Jerome Webb, will be offering his insights into the Bankside Yards case with Christopher Stoner KC and Andrew Francis in our first panel session, which is called Some Major Window Cleaning. Is there a clearer view as a result? Rights of light following Bankside Yards.
Thanks very much, Michael. Well, over to us. Is there a clearer view? That's not necessarily a thing that lawyers want to hear, is it? Because we like a bit of obfuscation and room for argument. But as you'll be aware, I'm sure, and we're going to assume a certain level of background knowledge. There's been a huge amount of publicity about Cooper and Ludgate House, a decision that was handed down on the 8th of July by Mr. Justice Fancourt, 86 pages of close reasoning. I don't know whether I can recommend it or not, but you may well have already read it. And we're not just going to talk about Cooper and Ludgate House. What we want to do is, in theme of the conference, try and explore the impacts of that case on a situation where a client maybe comes forward and says, I've got this new development site. What should I be doing in terms of any rights of light? And I suppose the starting point, and in fact, probably before you get to that, is going to be assembling the team that you'll need. So I've mentioned the lawyers. We've also got the surveyors, rights of light and valuation surveyors. So who else are you going to aim in to have in your dream team to consider the site, do you think, guys?
Well, invariably it's going to be the architect.
Yeah.
And often there will be a quantity surveyor. You're thinking of valuing cutbacks and rebuildings, planning consultants. The client will often have an eminence grise, his or her agent, who will obviously be terribly important, especially if it's what I call an offshore client. You'll have an agent here who often will be doing the hard work. And anybody else who's got a finger in the pie, but it can be quite a large number of people, but they have to obviously be kept under control. And in fact, in Bankside Yards, for reasons I needn't explain, there did need to be, well, I was involved in the case at its earlier stages, there did need to be a degree of control over everybody and who was doing what. So it's a good piece of management, actually. Team management is key. Yeah.
And then I suppose one of the first things is going to be client says, I've got a site. We've got actually the plan that's the plan from the judgment you may recognise from Cooper and Ludgate. Just to give it a bit of shape, on the right-hand side as you look, the rather elongated quotation mark building, that is Bankside Lofts. And insofar as you can see a number in the middle of it, the Powell and the Cooper's flats were just to the north of that. The various blue properties that are there are what is going to form the Bankside Yards development. But on Blackfriars Road, you can see the bottom one, which has the angular side going off, is the Arbor building, and that was the one that was in dispute here. The other buildings have not. The Opus building, you can see just to the north of that is currently being built. The other buildings are not. I'm not sure about the one right next to the river, but certainly on the other Sampson House site, they've not yet been built, and they will be built out. There was evidence in the case that they need the profit from the other buildings to fund the development to move forward. So, but you can see from that there's quite a broad site. So of course, client may come along and say, well, I've got this site, and ask just the broad question, am I going to have problems with rights of light? So how do we go about trying to move that forward to a useful position, do you think?
Well, from a surveying point of view, I mean, we tend to always recommend to our clients that they start to address this question either before they buy the site or certainly very early on in the process. And it all comes down to principally understanding who your neighbours are. What is their use? What is their age? You have residential, commercial. Are there any buildings which are less than 20 years old, i.e. haven't yet acquired rights? Can light obstruction notices be served in good time to preserve rights, preserve your development freedom, restrict those rights? Do we have any historic deeds, agreements, covenants, any unity of season points? There's lots of things which need to be picked up and addressed. And the sooner you start to get a handle on all of that and understand exactly who you've got around your site and who else is developing. I mean, a site like this, you've got development potentially happening all around us. One Blackfriars, of course, had already gone up, but not long before. There's the 18 Blackfriars site, which got consent, and will that happen? Will that happen? There's 240, which hadn't long been up. So what's the historical development scenario? What's the background? What are we actually dealing with, and what sort of rights do people have over this site? And so that first piece of sort of due diligence is absolutely vital. It's as important as understanding where your red line boundary is. You know, if you don't even know where your land actually stops and your neighbour's land starts, you can't design the scheme. Well, likewise, if you don't know where your neighbour's easements are three-dimensionally over your site, how can you start to begin to understand what the development potential of your site is and where the risks are? And, you know, developers would never think, well, I'll just build on their bit of land over there because I can get more value out of my development by just building over their land. Well, that's what we're doing when we push through the envelope and start building into other people's easements for light. So understanding where that is really, really important. So that's the first step from the surveyor's point of view. That very quickly leads into the legal point, which is, okay, so we've identified these adjoining owners. What's actually on title? Okay, there's some historic deed here. What does it mean? Does it give us a freedom, or is it a restriction? Is that profile still valid? Are there Holborn and Bailey points? Are there unity of season points? There's a whole raft of legal due diligence which then needs to build into that picture. So getting very close with your property solicitor and then coming to council to get clear advice on points of particular difficulty, which in London there is always certain need to be some, and indeed on risk. So if we do want to start breaching any agreements or transfers, what does that mean legally? What's the risk? And what's our chances of that being challenged, and can we win? So all of those things are right up front, day one. Let's address them, look at them, get them out, see what it says.
Yes, from council's perspective, in my experience, the two key things that invariably come up, as Jerome has rightly said at the early moment, which is always the right moment, is first of all, for obvious reasons, a lot of the rights will simply not be on titles because they're prescriptive, and therefore the land registry titles will only tell you so much. And the other thing is, of course, where you've got leasehold interests. And there are all sorts of what I might call poo traps for heffalumps with leases, reservations, development clauses. One of the things that did actually come up in the early stages of the Bankside loss litigation was the presence of a development clause in the leases, the flat leases, and whether the developer could actually take advantage of those development clauses. That was eventually not a point that was litigated at the trial, but it was a preliminary point or a preliminary question which came up certainly the early stages of the litigation. And so there are all sorts of things. And the other thing I would mention, particularly on this site and others, which I've actually had on other one on the South Bank, is our little friend, what goes underneath. Endless things with high voltage what do they call it? High voltage cables, UK Power Network, tube lines, all sorts of stuff. Disused tube lines near Waterloo. So you have all of that, which all your team, that's why it's so important to have the right team, will be able to unearth. And it's also not just lights, but it's going to be covenants, other easements, potential arguments for adverse possession. What's that bloke in the cigarette counter? That little cigarette sort of canteen thing in the bottom of the building. He's been there for 1 million years. What right's he got to be there? I mean, there used to be one in Holborn, up from Holborn Tube. It was there for years, and you often wonder what was going to happen when that building was redeveloped. He will say, well, I've got squatter's title or something. So there's an awful lot of clearing up to be done. And again, regeneration, the emphasis today is on regeneration. It's the aim to get this ready, and the Boris Johnson word, if I may use it, is oven ready. Get the site oven ready for the next stage of the regeneration, the input of all the capital investment. And that's why all of this at the early stage is so important. There's just as council, there's no skimping. Not that nobody here would want to do it, but we all see cases where there's been skimping. People think planning consent's the answer, etc. So that's a legal framework. I don't know whether Chris has anything to add to that.
No, and other than to totally agree and to emphasise the need for teamwork. And often the difficulty is what's not there as opposed to what's there. And that's been the prescriptive rights, whether it was Section 62 easements in relation, particularly leaseholds and matters of that sort. So that can be all very important. And of course, light obstruction notices is another thing that should be checked for. So there is this need to, I totally agree, really try and understand the site from a historical perspective and a legal perspective, and just try one's best to work out what rights of light there may be, as well as what other issues there may be in terms of covenants and everything. But obviously we are concentrating on rights of light. And then I suppose one then is working toward identifying what buildings may be of a particular problem, and how one might go about dealing with those particular buildings. Obviously, there will come a point in time where you may need to approach the owners of those buildings, but it is a question of having done the homework, or as Andrew puts it, getting things as oven ready as possible before that approach is possible. So I think yes, considering the precinct, as we sometimes put it, is hugely important.
And I would just mention the other point at this stage is, of course, thinking about can we square off any of this with indemnity insurance, which is terribly important. And also, if we're going to talk to anybody, we'll only talk to anybody if we can't get insurance to cover them off. So we clearly want to foul our pitch up on indemnity insurance by talking to somebody. In fact, we could have done indemnity policy for them, the low value, or not necessarily low value, but the low risk part of the spectrum. And of course, it's the, again, coming back to the precinct where you have a range. Can we insure that or do a quick deal on that? These are the difficult ones. Keep those to the end. And also, when we're doing all of that, I mean, again, regeneration, we come to us in due courses. Can we get our affable, amenable, whatever, local planning authority or anybody else to do a Section 203 override and get rid of everybody on an injurious affection basis? So that's the other point that can come in early. We can get ourselves into the mayor's parlour and see if we can get them to exercise their overriding powers. And in fact, that map shows the railway, and I've had cases where actually Network Rail have done that as well, because they have power under 203 to do that. So there we are. Yeah.
I think that's an important point. So, once you've assessed your risks, is then about, well, what's the plan, the strategy to mitigate that risk? And obviously, design is one. So one always works with the client and the architect to try and minimize the impact wherever is possible. You don't want to be paying for insurance or compensation if you don't need to. If by moving a building 2 meters left or right removes a risk or reduces it, why not? Particularly if you've got a big site like this. So design out as much as you can. Then, of course, insurance, which I just mentioned, plays a vital role, although I think this decision may just change the way in which some of those risks are now calibrated. I think you mentioned low risk. Normally one might consider low risk where there's a small loss of light or is a long way from the site. We'll just insure it, and if they come and raise the issue, we'll deal with them. I think that concept of low risk is perhaps now a bit more questionable. And I think from a surveying point of view, we'd be looking to advise clients, once you've done your early work and you've identified where those low risk properties are, why are we calling them low risk? Is it because the injury is small, which is usually the case? But that might be also because we don't know the room layouts, we don't know how the building's laid out. So we would probably be saying now to clients, I think we should go and try and get floor plans or try and get in and measure that building up. We don't need to alert them as to why, but we just say we're looking at redevelopment nearby. We want to understand your building. But that way we can get a much more certainty around that building, and it'll either then say, well, the injury falls away because actually now we know it's well lit, no longer need to worry about it, or it clearly is a risk property. And therefore that might mean that we go into a more proactive approach with that neighbour in due course. But this sort of properties which sit on the cusp, and the Bankside, basically the two claimants, the injuries were not particularly big. And yet they posed the biggest risk to the scheme. So low risk became very high risk. So how do we, as surveyors and lawyers, advise our clients? Well, actually, we need to move that category. We need to understand what low risk actually is, and then be able to say it isn't low risk or it's no injury, it disappears. So that of course all feeds into the insurance structure, and that is a very close interrelation between client, broker and underwriter to get the policy exactly right, very bespoke to the specifics in each case. And then of course, yes, the proactive negotiation. When do you approach? How do you approach? And when to bring the local authority in, because I think 203 is inevitably going to become more a part of our day-to-day approach on major developments, and bringing local authorities on board where there is clearly a public interest for the development and get them lined up should it be necessary to evoke their powers. So I think all of those things are key parts of the armory. And obviously, again, whether you're looking at a big master plan or there's not a major master plan, it's quite a big site, numerous buildings. The strategy is rather different because here, Arbor on its own, being built on its own, not causing a problem to anybody. Plenty of light towards neighbours, and yet they still got into trouble. So how does that affect the planning, the phasing of major master plan developments? And bringing that into the strategy, which parts of the site are going to be built first? What's their impact? What could be the cumulative effect? What could neighbours try and argue to create a case? So all of that needs to be now thought about in a bit more detail up front.
For those who perhaps aren't familiar with the detail of the case, just to put it in context as well, the impact of Section 203 in this case. I mentioned earlier that the Arbor building was the one that was in dispute. The Arbor building was completed in late 2021, and then the local authority passed a resolution invoking Section 203 in January of 22. So effectively the first building had been built, so that stood outside the Section 203 agreement, but the others are all covered by the Section 203 agreement. So they, in terms of any impact there, the statutory compensation, so we're not talking in terms of injunctions and negotiating damages, etc. So that was just the background. I do agree. I think one of the things that's coming out of the case, and given particularly in metropolitan areas, the demand for housing, etc., is that Section 203, you've got to think that it's going to be invoked, or there's going to be negotiations with the local authority to invoke it a lot more than there perhaps have been in the past. Because, as in this case, the usual way is that there's a transfer of the land to the local authority who passed the resolution. And I think in this case, there was then an immediate lease back of 999-year leases, and then an actual transfer back, all within the space of, I think it was by May 2022. So that's how you engage your Section 203. So yeah, it's going to be critically important. But let's move it on, and we've got our site, and we've got our thing. There was lots of talk in the decision as well about a settlement fund, and I guess one of the things that the client's going to be interested to know at the outset is what sort of level of money should I be setting aside if I'm going to have claims. And I think one of the things that comes out of the judgment to me is just a reinforcement. I don't know what you both think about. Actually, there's quite a lot of front loading of the work in terms of trying to work out as much as possible how much there might be paid. And we'll come on, obviously, shortly to discuss what was discussed in terms of damages in this particular case. But is that fair comment? Do you think that it's trying the best we can to identify some form of fund set aside as a cost of the development?
Yes. Yeah. And then that big question of, well, how do you calculate what that fund is? And again, this case helps us to some extent because the judgment is clear that it's not how much light they previously enjoyed, it's what they're left with, which is important, which always used to be a fairly key principle in rights of light. It got a bit muddy in the last few years, but it's been reclarified, I think, in this judgment. So that means that your starting point is and it reaffirms Waldron methodology. Whether that's good or bad, we can debate that another day, but it's helpful because it gives a very clear methodology for how to assess it. So where do you start? Well, you start with being able to take away light to all your neighbours to the point where they are just adequately lit, i.e. they are 50% of their light, 0.2% gone to their building. So that may be way bigger than the existing building, but it may be smaller than what you want to build. But that then becomes your starting point. And you're then looking at, well, what is the increase in development area over and above that envelope to what you wish to construct? Is that 10 floors, 5 floors, 3 floors, whatever? So that is then the bit where you're looking at the negotiated damages as the base of compensation. So how much of the profit or the gain, the development gain made by building that part outside that envelope needs to be shared with the neighbours. And which neighbours and what's the apportionment. So there's quite a complicated, pretty on a site like this, quite a complicated piece to understand, well, who's affected by that and by how much, because there might be 20 neighbours who all have to share in that potential compensation pot. And how much of that pot should they be sharing? Is it 5%, 10%, 20%? In this case, it was 12.5%, but that's very, very case specific, and I certainly wouldn't take that as a rule of thumb, say, oh, it's going to be 12.5% wherever you go. Not at all.
Yes. I think that the point that Jerome's just made is terribly important. What we often call the fair percentage of the net development value. How you reach that net development value, again, we haven't got time to explore today, but that's looked into in some considerable depth in the judgment. But I have two cris de coeur, if I may come straight out with them. One is, as my old biology mistress used to say to us at school when we were misbehaving with frogs' entrails, she was sick, sore and weary of us messing up. And I get sick, sore and weary, with great respect to those who sometimes indulge in it, of stating it's got to be Stokes, it's got to be 1/3. Well, Tim Fancourt says no. And I've been saying that for many years. And in fact, when you look at the cases, the fair percentage is anywhere between 5% to 90%. And there's cases in between, all fact specific. So let's just stop saying it's got to be Stokes. We may have to educate our clients, we may have to educate our surveyors and all sorts of other folk. The other thing, which is my other little cris de coeur, which also comes into this, which, this judgment actually marks a departure, along with two other judgments in the last decade or so. One is Fentigers, which is 11.5 years old in the Supreme Court. And the other one is Beaumont, which was in the City of London, which was a decision of Peter Knox, QC, KC. That must be 5 years old now, if it's that age. Why is 6? Well done. Why is it, and this is a great deference to our learned surveyors here today, why is it that every time, not every time, but loads of times, I look at the standard text, not in GIA's reports, but in others' reports, this is again where we need to educate our clients and everybody else to take note, there's always this reference to Shelford, Heaney, Regan, and all those rubbish cases before Fentiger. Well, let's start with 11.5 years, Fentigers, Beaumont, and then we've got the balance, etc., as exemplified in Bankside. And that's really what I think we can all do, is tear up our standard guff and say, right, let's start with this. This is really our, whatever the word, our word is, our in a sense, not quite a Bible, because there's no Bibles in this case, but it's our starting point, really. It's our vade mecum, which we need to sort of have with us. And that's really coming back to the point about low risk, high risk, and everything else. We've got to be terribly careful. This is where the insurance market's got the jitters, talking to some of my underwriting and brokerage friends. They got the jitters because you've got 2 flats, each worth just over £1 million each. You've got one getting £500,000, one worth 350, of some pretty minor injuries, 2 bedrooms in one and a bedroom and a living kitchen diner in the other. They weren't the finest flats. They weren't the dining room at the Ritz or anything. And the jitters there are, these were potentially somewhere away across the other side of the railway line, quite a few yards to the east. You wouldn't have thought that it would come out with £500,000 and 350, but they did. And the thing that follows from this, the low risk thing, is we now have to be terribly careful not to patronize what I might call the former low risk folk by saying, oh, well, no, X pounds square foot, £5 a square foot, YP, blah, 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 splodge 3.666 recurring, go away with 5 and 10 pence in the pound. We can't do that anymore. And we have to be very realistic. And this is, again, coming back to regeneration. Getting in there early and sorting out these things on a proper basis is really key, actually, because otherwise we're going to be falling over ourselves and creating unnecessary barriers by operating at the low risk end and saying, well, there you go, you're only entitled 10 and 3 in the pound or whatever it happens to be. No, let's come up with some realistic figures here, because people will be aware. The internet, all the other resources, people will be aware. They're already coming through my door saying, what about this case? What about this case? Blah, blah, blah. And that's it, really. But what I think we might want to hear, subject to what Chris said, I would like to hear from Jerome, I'm sure we'd all like to hear from Jerome, what he thinks about the realities of measuring light these days, in terms of, we've got those various methods, we've got Waldron coming at the top. How does he think, Jerome thinks it might go in the future? What's the way forward here in terms of either practicality or moving things on a bit?
Sure. I think up until this case, everyone was sort of pinning their, well, a lot of people, not everyone, was pinning their colours to the mast on radiance-based assessments and more sort of sophisticated computer analysis and lights and all the rest of it. This judgment pretty much lays to bed. His decision was nay. Waldron stood the test of time, is very straightforward, is very easy to understand. That's the method. So where does that leave us for the future? Well, I think the courts don't like change, and where we need to go is move it forward in small increments, because it does need to be moved forward. And he acknowledges, Fancourt acknowledges in the judgment that there's room for modernisation and improvement, but just dropping it and moving to a whole new system was not the right thing to do. And I do tend to agree with him. So if we take Waldron as the methodology, it's then about the figures and the calibration, and he talks about that in the judgment as to how that method is actually used. Now, 0.2%, I'm getting into all the technical stuff, but on a grey December overcast day, 0.2% of the sky is giving you 1 lumen of light. Well, that's what Percy Waldron said was the minimum, the necessary for the ordinary notions of mankind, i.e. being able to read small print of the Times. So where does that leave us today? Well, we need to carry out some new research. We need to understand, first and foremost, how much light do you actually get from 0.2% of the sky today? Because in 1920, London was a city where pretty much every building was heated by a coal fire. And the air in London was pretty polluted. Clean Air Act has come in the 1960s, sorted all that out. And the light that we get from the sky in London now is 75% brighter than it was in 1920. So 0.2% of the sky in 1920 generates an awful lot more light than it did back then. But conversely, we as humans have got used to enjoying much better quality of light than they had in 1920. Most people might have a gas lamp or candles in their homes and offices, and working with daylight was rather more important. So people's expectations of what is an adequate level of light have shifted. Where does that leave everybody? Well, we don't know, but we do need to do some research. And GIA with the BRE, Anglia Ruskin University and the RICS are currently trying to pull together some research on exactly that and do some proper scientific empirical evidence to find out, if you put someone in a room and you turn the light right down, what is the minimum point at which you say, I can't now read? Because we're not talking about good light, we're not talking about, oh, this feels comfortable light, we're talking about just enough light to do what I need to do. So that research needs to be done. We can then use that back in the Waldron method and bring that back into the court. So the methodology stays the same, but is brought up to date with more robust scientific research.
Yes, There is Percy Waldron was a man I thought he'd been killed at Dunkirk. Somebody once said he'd been. In fact, he soldiers on to a great age, and in fact, you can find a photograph of him with a wing collar, looking a bit like Neville Chamberlain without the moustache, somewhere up there. And he was an architect, and he designed something famous. I can't remember what it was. Anyway, in the late 19th century, his book, which I've got published in the 30s, there's 2 volumes of it. I've got Sir Robert Bagary's copies, his sale of his library. In the late 19th century, the Germans, with us, have some very clever scientific research done on light, and particularly in room spaces. There were proposals by the Board of Education for the London, particularly the London board schools. There's ones you now see around London, big Victorian Edwardian with huge, great high windows in them. It should be 0.4% at the sill level. For some reason, that was never adopted. And that would be a much better standard. And also, I did a case a few years ago in Gibraltar, and there's a case in the 1930s, which Mr. Waldron was involved in. It's mentioned in his book, Thompson and Belancey, in about 1934, where it was accepted by the experts, Waldron, and I can't remember who the other one was on that, the other side of this case, that the total sky, the dome of sky, should be 1,500 lumen rather than 500 lumen, because, of course, it was brighter and nearer the equator. It might be said, apropos your point about the dome of sky now being a bit brighter than it was 100-something years ago, we could go to 1,000 lumen, never necessarily 1,500, it might be a bit optimistic, but some standard that would bring us up to all the reasons that you've said reasons have changed. And, of course, we are, modern lighting is so much better as well. And what we haven't had yet, and we've had a few near misses, is a case on modern lighting standards in Class A1 offices, where the court has to consider the adequacy of artificial lighting in A1 offices. We nearly had that in Midtown about 20 years ago. We didn't. But anyway, I think it is bringing up to date, and I think it would be good to have a standard that we can all do get our slide rules out and recognise rather than other things. But that dates me. But anyway,
Just before we run out of time, and get thrown off the stage, I just want to just touch upon what the case teaches us in terms of the inevitable question, so simply put, but so difficult to answer from the client, as they always are. Is there going to be an injunction, or is there going to be an award of damages? I'd venture to suggest that in terms of what this case tells us on the injunction, the critical point is where Mr. Justice Fancourt confirms that Fen Tigers sets a new standard, so to speak. In itself, perhaps quite surprising 11 years after the event that needed to be confirmed, but perhaps evidence the disregard that the pin of Fen Tigers over that period of time. But beyond that, the case is very fact specific. There's some unusual facts, won't go through them now, but in terms of lights cases, you should have this case with you when you're considering that question, but at the same time have Beaumont and Florala from 2019, which is perhaps at the other end of the spectrum insofar as you've got a fairly minor infringement of some lights in an office space. And the order that was made there was a cutback. So there was an injunction. So whereas on the face of this, one could make a case out for saying this is very public spirited and the factors are there, I think that a particular factor in this case is that because of the Section 203 influence, the evidence that the judge accepted was that Arbor probably wouldn't be cut back. It would actually be demolished because it would be cheaper to demolish it. And all they would do is they would go back and they would get planning permission for a larger tower. And that would be covered by the Section 203. So that seems to me to be quite a compelling reason not to go down the injunction route. But I don't know if that's a fair comment.
Well, some really fascinating insights. Thank you very much to the panel. I think that all proves to us as real estate professionals is that rights of light litigation disputes generally is just the gift that keeps on giving, notwithstanding the consolidation of the law in cases like Bankside Yards. So can I just ask you all please to thank the panel in the usual way?